Debbie is the real person who can talk to this research, which was fantastic and really game-changing for disabled lawyers in the profession. So, Debbie, please talk to us about, firstly, why did you decide on the legal profession when you could have researched anything?
Yes, thank you, Lizzie. Is my volume okay? You can hear me all right?
Yep, all good.
Lovely. Yeah, great. Thank you. Yes, well, looking at the legal profession, I was particularly interested in the fact that the legal profession had a lot of equality and diversity initiatives. But when I looked at it, I couldn't actually see any initiatives that were aimed at disabled people in the legal profession. And increasingly, when myself and my co-researcher, Natasha Hurst, looked at the reports and the literature around in this area, we just thought, well, disabled people seem to be unexpected. They're missing completely. So why was that? Given that the legal profession was doing quite a lot of diversity and inclusion work in other areas, such as gender, race, LGBTQ+, you know, sort of socioeconomic issues, why was disability absent? And as we talked to more and more people in the legal profession, it became apparent to us that there just weren't many visibly disabled people. And I don't think that is because there were very few disabled people around. In fact, what we discovered when we got talking to disabled people within the profession was that most of them had non-visible impairments or health conditions. So they often didn't present as a disabled person. And that also meant that they didn't have to self-identify as a disabled person. Now, the other side of the equation as to why we were interested in law was because unless disabled people are represented in a professional capacity, particularly like law, the operation of law can be affected. Bringing your lived experience to your practice, your professional practice, is really important. And it also brings insights about how to treat clients, how to treat litigants or defendants, and what kinds of issues are important to them to make them able to fully participate in the legal process. So these were some of the issues, and I'd like you did you reveal the outcome of the Slido? Because I don't remember you doing so.
I can't see it on here. It was going. We've certainly not revealed the correct answer yet. So if you want to, it's right in front of me. There we go. 47%, thank you, of people said it was 5%, they thought.
Okay. So that's similar to, you know, I mean, we asked in one of our interviews and questionnaires about how many people reported the fact that they were disabled if they had a non-visible disability. So over 90% of respondents surveyed reported having a non-visible impairment. 70% exclusively reported a non-visible impairment. An additional 20% identified as disabled people with both visible and non-visible impairments. However, only 50 to 60% said they disclosed their non-visible impairment when applying for training, jobs or tenancies. And even when somebody had a visible disability, they often didn't declare the fact that they had a non-visible impairment as well. So we found that quite interesting that you know, there are disabled people within the profession, but very few of them were declaring.
Well, so you've somewhat started already on my next question anyway, Debbie, which was going to be, in probably 3 minutes, which is going to be really difficult, can you sum up what you think the key, this is a huge research report, just to bury the lead with this. What do you think can you distill into sort of the next 3 minutes of the real key findings?
Yeah, well, I was going to say a little bit about what we did in terms of co-production, because we work with the Disabled Solicitors Network.
Sure.
And it was really important that we co-produce this research with disabled people within the profession. And because we were funded by disability rights organisations, they wanted us to demonstrate that disabled people within the profession were getting something out of the research, even if this was raised awareness, but also that they were full participants in the research, because within the disability rights movement, there's a saying, nothing about us without us. So, you know, you need to integrate disabled people and their lived experiences into everything you do. And we used focus groups, we used interviews, and we eventually used a questionnaire. And the two key sort of areas I wanted to highlight in terms of findings was getting into the profession and getting on in the profession. So in terms of getting into the profession, we found a lot of solicitors had problems getting into the profession because of stereotyping, the assumption that, you know, they wouldn't be able to do certain jobs. These were sort of misconceptions, but also recruitment agencies who seem to filter out disabled candidates. At the bar, for example, we had a lot of barristers say that there were very stereotypical views of what you could and couldn't do as a disabled person. And this sort of was about how they presented themselves or how they looked and sounded. And, you know, there are ways around this, and not all aspects of the legal profession you're standing up and doing advocacy. You might be doing, you know, a lot of office work behind the scenes or working face to face with clients. So we have to see these as stereotypes and myths that need to be sort of addressed. Mm-hmm. There was also accessibility of employers. Lots of people said they turned up for interviews and they couldn't even get into the building. So why is it that firms aren't putting on their websites, you know, where you can get reasonable adjustments, how you get into a building, what sorts of facilities are available in the premises that they have? This should be really standard. And some areas of the legal profession were more accessible than others. So, and getting up into the profession, 58% of solicitors and paralegals surveyed believe their career and promotion prospects are inferior to non-disabled colleagues. Over 80% of respondents reported the process of requesting adjustments caused them stress and anxiety. And a huge number of people said they didn't request reasonable adjustments they were entitled to because they were fearful of being discriminated against. So we had a lot of people saying that even though they knew that they had an entitlement to adjustments, just simply self-identifying as disabled was going to disadvantage them in their career. Would you like me to say something about some of the recommendations?
We certainly can do. We might be skipping ahead a little bit, but we certainly can do. That's great.
Okay, so in terms of getting into the profession, we focused in our recommendations on things like work experience. Those disabled candidates who'd had prior work experience found it easier to get into the profession because they had that experience. So we were recommending that work experience placements and training places were reserved for disabled candidates simply because their underrepresentation was so out of kilter within the profession. So if you look at other sectors like the media, the BBC have earmarked certain roles for disabled candidates because they want to and they identify that they need to increase the representation of disabled people within the profession. Things like part-time provision of training contracts and part-time opportunities to do work. You know, as a lot of women in the profession have found, these can be problematic, but for disabled people, having that flexibility was essential. Mentoring and reverse mentoring from senior colleagues and mentoring back to senior colleagues so you could share your lived experience was something that we also recommended because disabled people had found it useful. Monitoring and evaluating recruitment agencies and looking at the use of artificial intelligence in recruitment was something else that we spotlighted as important, because of the fact that, you know, you could be using sort of ideal worker norms, sort of saying that you've got to have certain characteristics and not thinking about the adjustments you can make for disabled people. Accessibility in organisations is an anticipatory duty to think about accessibility for clients, but not for employees. So why is that? And should the regulator be saying, well, if you're doing it for clients, why are we not doing it for employees so we can increase the accessibility of disabled people in our profession? Getting on in the profession, we were thinking about things like disabled people having expectations of networking within the profession was really difficult. But also we found that a concept that we came up with was something called misplaced paternalism. We had a lot of disabled people tell us that they wanted to do challenging roles, but often their line managers were saying to them, well, you know, I didn't put you up for that, or I didn't put you forward for that because I thought I'd give you an easier role. But that was really, really patronising, and it also stopped them from getting on in terms of their career progression. And so thinking about those sorts of things, we were saying you've got to better understand the issues around progression. Absolutely. And make reasonable adjustments during progression.
Yeah. And look, as I say, we could talk about this all day. You can tell it's a very meaty report. And what I would say is I would encourage you to either read the full report, which you can do online, or you can read a summary of the findings. So look, that paints a very bleak picture, or it did in 2020. The good news is lots of people were really encouraged by this report because it gave a lot of credibility and weight to what disabled professionals have been saying for a really long time and people's lived experiences, right? So with the help of Debbie and Natasha, we at the Law Society really had some motivation and some encouragement to get moving. I'm really conscious of time, so I'm going to do a very quick drive-by of everything we've been doing in the last 5 years, okay? But what I would say is, please do get online and have a look at what we've been doing. We've got some fantastic resources for your organisations, okay? And that includes things like easy wins for organisations. That's split into large organisations and small organisations, depending on where you come from. Best practice for reasonable adjustments, what does that look like? And that might be things, for example, like saying to everybody at interview stage, what do you need to thrive here at our organisation? We're not just singling out disabled people, okay? So things like that. We've since launched Project Rise, which is the project that I lead at the Law Society, and it looks to get part-time training, which was a big problem, as Debbie said, that was a barrier for entry into our profession. It looks to make that standard across our industry. So no longer will disabled trainees be prevented from entering the profession just because they can't work full-time. I'm going to leave on one question, Debbie. If you can say in one sentence, where do you think we're going? What is left to do?
Okay. Well, COVID was something that was really important, and the introduction of much more flexible working. Please do not let us backslide from some of the lessons that we learnt from COVID and the fact that the profession was much more accessible to a lot of disabled people. There's a lot to do on culture. There's a lot to do on reasonable adjustments still.
Absolutely. And mine is, well, to echo that really sustaining momentum with where we have gone and not to backslide. And we need a culture change. I noticed from the notes that someone has already said that this morning, but we really need a culture change in how we look at DEI more generally, and certainly to not be swayed by our American cousins where there seems to be potentially a shift change. Hopefully that's not going to be the same for us. Thank you so much. Appreciate your time.
Thank you.
Thank you very much for that.